The rules just changed for everyone, the Secure America Act. There's a new immigration law already in effect, and it's not a minor update. It's a complete shift in how your green card, visa, or citizenship application will be handled in 2025. Today's story is urgent. It affects every immigrant, sponsor, and applicant currently in the system, and especially green card holders. What is the Secure America Act? The Secure America Act, also known as H.R. 1, is now the backbone of the Trump administration's immigration crackdown. Signed into law earlier this year, this act isn't just a list of new policies. It's a full-on infrastructure shift. It aims to tighten security screenings, reduce public benefit use, centralize immigration decisions, and drastically limit officer discretion. Even longtime U.S. residents are no longer exempt from rescreening, income scrutiny, or enforcement risk. Whether you're applying for a green card, renewing one, sponsoring a spouse, or seeking citizenship, your case now faces a new standard of review. What's already changed since August 1st? Key provisions of the Secure America Act took effect on August 1, 2025. Others begin enforcement August 21st and beyond. Let's walk through what's already active and what it means for you. As of August 1st, fee waivers are extremely limited. Biometric data is required for nearly every immigration filing, and USCIS has begun sharing applicant data with other agencies like the IRS and DMV. Then on August 21st, USCIS initiated full rescreening for green card renewals, activated DMV crosschecks for identity, and began public charge enforcement using stricter financial criteria. And yes, this applies even if you've lived legally in the US for decades. Green card renewals now face full background checks. Previously, Form I-90 was a simple green card renewal. Not anymore. Under this new law, renewing a green card now triggers the same level of screening as a brand new application. That means full background checks, tax return audits, work history reviews, and criminal record scans. Any mismatch between your past filings and current application can flag your case for denial or investigation. Minor legal issues or inconsistencies, things that were overlooked before, are now treated as serious barriers to approval. Fee waivers nearly eliminated. If you were hoping to apply without paying a filing fee, prepare for disappointment. Fee waivers are now only granted in rare cases, and you'll need to be well below the federal poverty level to even qualify. Undocumented immigrants and DACA recipients are specifically excluded, and if your waiver request is denied, your entire case can be rejected unless fixed fast, no second chances. Biometrics required in nearly all filings. Almost every immigration process now requires fingerprints, photos, and facial scans. This includes renewals, work permits, citizenship applications, and even some family-based petitions. And for the first time, even U.S. citizen sponsors may be required to submit biometrics for identity and background verification. This biometric data is shared with law enforcement and employment databases, which makes previous unauthorized work history or false claims far more traceable. Cross-agency data sharing is now standard. Under the Secure America Act, USCIS doesn't operate in isolation anymore. Your case is now analyzed in coordination with other federal databases. That includes the IRS, Social Security Administration, DMV, and more. This means your tax returns, driver's license, income, and work history are all matched against your immigration file. Any mismatch can delay, derail, or even deny your case. In the past, small errors might have gone unnoticed. Not anymore. Data inconsistencies are now automated red flags. The new public charge test is much stricter. The Trump-era public charge rule is back, and stronger than ever. USCIS now requires you to prove full financial self-sufficiency to qualify for nearly any benefit, renewal, or adjustment of status. If you've used government aid like SNAP, Medicaid, or Section 8, you're now at risk of denial. Even temporary benefit use can hurt your case, especially if not clearly documented or explained. And simply unenrolling now doesn't erase the record. The law focuses on your history, not just your present. Affidavits of support are under a microscope. Sponsors are now under pressure too. If you're sponsoring a relative, your Form I-864 must be backed by high, stable income, plus verifiable tax returns, bank statements, and employment letters. Weak affidavits are already one of the leading causes of denial, and under the Secure America Act, that trend will accelerate. Expect zero tolerance for vague or inconsistent sponsor records. Who's at risk right now? Let's talk about the groups who face the greatest risk under this new law. First, anyone with a criminal record, even if charges were dismissed or sealed, is under immediate scrutiny. Second, if you've ever received public assistance, even short-term food stamps or Medicaid, your application could be flagged for review or outright denial under the new public charge rules. And third, if you've worked off the books, missed filing taxes, or have unreported income, USCIS will know. Data from IRS, employers, and Social Security is now fully integrated. Who might benefit from this new system? It's not all bad news. If you have a clean record, strong finances, and consistent documentation, your case may actually move faster under this new streamlined system. Applicants with clear work history, no red flags, and no benefit use might benefit from less officer discretion and more consistent processing standards. Employers filing legal work visa petitions, like H-1B or EB-3, may also see faster approvals when their compliance records are strong. Family sponsors with high incomes and airtight documentation might experience fewer RFEs and delays. What documents you must now prepare? Every applicant should be preparing a stronger evidence package than ever before. That includes valid passports, prior USCIS approval notices, and copies of your current or expired green card. For financial proof, gather 3 years of tax returns, W-2s or 1099s, 6 months of pay stubs, and employment verification letters. Add lease agreements, utility bills, or mortgage statements to show stability. And don't forget, USCIS now expects many applicants to provide an FBI background check or police clearance certificates. For smart strategies to protect your case. First, fix your tax history. If you haven't filed taxes or made mistakes in the past, get them resolved now. Hire a licensed preparer, and save all confirmations and receipts. Second, exit public benefits if possible. If you're currently on SNAP or Medicaid, consider transitioning to private or employer-based options. Keep proof showing when and how you stopped. Third, strengthen financial evidence. Prepare your sponsor's documents in advance. Ensure all deposits in your bank statements match job income, and remove anything suspicious or unverifiable. Fourth, address criminal issues now. If you've ever been arrested, even if it was resolved, request an FBI identity history summary, and consult a qualified immigration attorney for next steps. Final thoughts: 2025 is a turning point for immigration. This isn't just another Trump-era update. The Secure America Act is a full reset of how immigration works in the United States, and it's already live. You're no longer dealing with one agency or one form. You're dealing with multiple government databases, centralized enforcement, and zero margin for error. If your records are clean and your documents are organized, you can succeed. But if your history has gaps or risks, now is the time to fix them. If this video helped you understand the Secure America Act, don't forget to like, subscribe, and turn on the bell icon for future updates. Thanks for watching. See you in the next video from US Immigration Intel.